Sawadee Krap, and welcome to another episode of the podcast. Today, we're going to discuss an important topic regarding the division of inheritance in Thailand. Specifically, what can be done if the estate administrator refuses to divide the inheritance properly? This situation can be divided into two cases. In the first case, the estate administrator fails to divide the inheritance at all. In the second case, the administrator divides the inheritance improperly, causing damage to the rightful heirs. In Thailand, there are 4 legal remedies that can be pursued in such situations. Let's discuss each one in detail. The first method is to withdraw the trustee according to Section 1727 of the Civil and Commercial Code. This can be done if the trustee fails to fulfill their duties, such as not dividing the estate within 1 year or hiding the amount of the estate from the heirs. To initiate this process, a request to withdraw the trustee must be filed, followed by a request to the court to appoint a new trustee. The court will then send a summons to the current trustee, and all parties will enter into an agreement on the division of the inheritance. If an agreement is reached, the case will be concluded accordingly. However, if the parties cannot reach an agreement, the court will consider the validity of the original administrator's actions and the accuracy of the inheritance division. It's important to note that the request to withdraw the trustee must be filed before the estate administration is completed. Otherwise, if the assets have already been divided, a separate case must be filed, and it may not be possible to withdraw the trustee. The second method is to sue for the division of inheritance. In this approach, the current executor is still expected to perform their duties, but a lawsuit is filed to compel them to fulfill their obligations according to Section 1719 of the Civil and Commercial Code. This means suing the executor to carry out their duties as required. The third method is to file a lawsuit to revoke the transfer of inheritance. This applies when the trustee sells the property to a third party against the majority of the heirs' resolution, sells the property at an unreasonably low price, or transfers the property without compensation. Under Section 1724 of the Civil and Commercial Code, such actions do not bind the heirs, and they have the right to sue for the revocation of the transfer. However, it's important to note that if the third party involved is an honest purchaser, the transfer cannot be revoked, and the damaged party may need to seek compensation from the executor. The fourth method is the most severe and applies when the trustee embezzles the estate. This is considered a criminal offense under Sections 352, 353, and 354 of the Thai Criminal Code, with penalties including imprisonment. It's crucial to act promptly in such cases, as according to Section 96 of the Criminal Code, the lawsuit must be filed within 3 months of discovering the offense and identifying the offender. Failure to do so may result in the case expiring. In summary, if the estate administrator in Thailand refuses to divide the inheritance properly, there are 4 potential solutions. These include withdrawing the trustee, suing for the division of inheritance, filing a lawsuit to revoke the transfer of inheritance, or pursuing a criminal case for embezzlement. It's important to consult with a qualified legal professional to determine the best course of action based on your specific circumstances. Thank you for listening to today's episode. I hope you found the information helpful. Until next time, Sawadee Krap.